The bill, I urge passage.
Lady from the 19th, Delegate Kraus.
Thank you, Mr. Speaker. I too agree. This does no harm to the bill, and I urge passage on it.
Is there other debate on the amendment? Is there other debate on the amendment? Does the sponsor wish to close debate on the amendment? If not, those in favor of adoption of the amendment will please say aye. Those opposed, please say no. Ayes have it. Chair declares that amendment adopted. Clerk will please report the next amendment.
Delegate Fluharty and others move to amend the bill.
Are there objections to allowing the sponsor to explain the amendment in lieu of having the amendment read in full? No objections are heard. Chair will recognize the sponsor, the gentleman from the 5th, Delegate Fluharty, to explain the amendment.
Thank you, Mr. Speaker. This amendment, you've probably heard about it in the press. It's made local press, made state of West Virginia press, it's made national press, and that's Raylee's law. I'm sure you've seen some emails, and we've discussed it on this floor before. It's made national news. Unfortunately, it hasn't made the Education Committee agenda yet. And what it does, and this is a very narrowly tailored version of Raylee's law, so let's go over what it does and doesn't do. So it states that authorization of instruction in the home will not be allowed if there is a pending CPS investigation and that investigation was made by a school teacher or school personnel, only under those narrow circumstances. So if there is a pending investigation from outside of that narrowly tailored version, if it's a disgruntled ex, if that makes a report, anybody like that, that would not qualify here. It only qualifies if the report is made by a teacher or by school personnel. Only under those narrow situations, those circumstances, would a county board not authorize instruction. So that goes back to Raylee Browning. Raylee Browning was 8 years old in Mount Lookout Elementary School in Nicholas County. She was being abused, and her gym teacher, Carrie Ciliberti, made a report that she was being abused. While that report was pending, Raylee was yanked out of school. She was tortured, abused. She was starved to death. 8 years old. She died the day after Christmas. She came down with sepsis because she was drinking from the toilet. Excruciating set of facts and circumstances. And I know there have been concerns on how broad Raylee's law was originally written, and I've had many communications with many members in this body, and they were concerned, well, what if there's just a pending report by a disgruntled ex? We took care of that, we took it out. This is narrowly tailored to a teacher or school personnel. They are mandatory reporters, as many of you know, mandatory reporters. They have to report abuse. This happened in Raylee's situation, and she's not with us today because she was able to be yanked out of school while a pending report was out there. And 3 individuals are now serving time in prison. And I will say this, Judge Blake, who presided over the trial, he said he saw blame in a system that could allow for a child to be jerked out of school and homeschooled without any real measure to ensure the child's continued safety. That's what this does. This does what Judge Blake wants us to do. We get a set of circumstances and facts. We as a body can review them and pass legislation to help protect children. That's exactly what this does. I agree with Judge Blake. We can do this, and we can keep them in school for a longer period of time so they're not being sheltered and they'll be visible for the protection they need in this certain set of circumstances where a teacher reports abuse and then the abuser attempts to take him out of school and homeschool. So that's the very tailored version. I'm happy to answer questions and reserve the right to close, Mr. Speaker.
Gentleman from the 64th, Delegate Burkhammer is recognized.
Thank you, Mr. Speaker. Will the gentleman yield?
Sure.
All right, so what we're looking at here is kids that are in school and not being allowed to be removed from school.
Correct.
So if you're already homeschooling, this would not pertain to you.
Correct.
Okay. So I first want to say I know we had this discussion last year, and I appreciate that you've worked on it and tried to get it better, I will say, and moved in the right direction, where last year that was just upon allegation, and I really did feel like that it was attacking homeschoolers. So I appreciate your work on that. But I do want to ask some questions about how this process would work. So in code, you cannot know, no one can know who's reporting a CPS case. Do you agree with that? I mean, that's an anonymous report.
I agree to an extent. However, when you want to remove a child from school and there's a review of the individual reviewing, this would be so narrowly tailored that the report would have been made by an individual in the school district itself. So the school district has a review process before the child leaves. This would just prohibit that while a CPS, so in this situation, it was the gym teacher that made the report.
So, but how would the school district ever know? Like those complaints are completely anonymous. So when I call in and make a complaint, and let's say I'm a teacher, no one in the school districts knows that I made that complaint. My name is never released. It is 100% completely confidential. So I don't know how it implies, and I want to make it, I'm not trying to hurt this. I believe your attempt is headed in the right direction. I'm just trying to figure out how to make it work.
I would say that under 803, it's not exactly anonymous, because 803 specifically states who is a mandatory reporter, and teachers and school personnel are mandatory. So we have many teachers in this body here today. They know. And not only that, I have narrowly construed it so that 803 includes emergency service personnel, things of that nature. That wouldn't even be included. This is just purely school teachers and school personnel, so it'd be within the confines of the school district.
Okay, I agree with you, a mandated reporter and that they have to do it. I'm talking about on the other end, when the school superintendent is authorizing the homeschooling or not authorizing the homeschooling, they have no way to know if there is a pending investigation, because that mandated reporter information cannot be released.
I disagree with that analysis, because there is in place now a system that talks about a mandated report and an acknowledgement signed.
But that's only through the mandated reporter, and they're not the one that is authorizing. So if it's the gym teacher that made the complaint, they're not the one that's authorizing the homeschool to happen.
And then, to push back on that, I would say, when it goes to review from the school district and there's a set of facts available, that there is a pending CPS report would be available. Now, that to me gives notice that there's a pending CPS report, and we would know it was from a mandatory reporter,
So,
because they've signed an acknowledgement form.
so now a school superintendent has to contact CPS every time that someone wants to remove their child to see if there's a pending investigation? And then they're going to have to know who made the
I don't know that
claim?
that is a set requirement. However, I would hope that they would do that now. That's the situation in Raylee's situation. There was a report. The teacher said on several occasions, I made a report and it was pending, but there was no prohibition. So now, under the set of circumstances, if the report is made, there's no prohibition that says when the school district superintendent makes a decision, there's no prohibition saying you can't allow this to happen because there's a pending report. Even if they have knowledge of the report currently, they still can let it proceed. And that's what happened here.
I'm just going to disagree with you.
That's fine.
That
It happens all the time
There
here.
is, that there is no way for the school superintendent to be made aware of a pending investigation because of the confidentiality that is required in code of these investigations.
I agree with confidentiality. I believe we get out of the confidentiality by the mandatory reporting by school personnel who signs an acknowledgement form. That's where we see a difference.
But you're going to have to step outside of that confidentiality to see who made the report, and was it a teacher or school service personnel in your district?
Yeah. So if you look at 803, which we were talking about, they have to actually notify the institution. So there's going to be actual knowledge by the institution, by the mandatory reporter, which goes to my point. When you go into the mandatory reporting section, the institution knows. So by the institution having knowledge of a pending report from a mandatory reporter, a school teacher, the gym teacher, school bus driver, there's your acknowledgement.
Okay, that's what I was asking is so there's not an additional step in this. They're already going to know this information.
Yes.
Okay.
They're already going to know the information, but there's no prohibition. This just adds the prohibition. We have this knowledge. There's a pending report from the gym teacher that student X may be being abused, and there's an investigation going. They have all that knowledge. This would prohibit based upon that information until there's a completed investigation. Very
Okay.
narrowly tailored.
All right,
Hopefully it never happens, but it happened to Raylee.
Yep. So next question, is there the opportunity for a parent to appeal that? So sometimes these investigations can string out for a long period of time. And if I was choosing to do this, to remove my child to homeschool, and someone alleged something, and now I can't, am I able to appeal that at any way, or I would just not be able to do what?
I would say under current law, a protective plan is supposed to be in place within 14 days. Now, I agree. Sometimes it takes longer and it shouldn't. We have a system that's not functioning at 100% right now. However,
So
I
I would
don't
say
think, think a mere inconvenience of 14 days or an extended time is enough reason to allow abused children to be taken out of public schools and homeschooled. We can agree to disagree on that, but I'm here to protect kids. This is a mere inconvenience if it goes on for an extended period of time.
So if so I will agree with you, there's a 14-day kind of within the imminent danger type things, but if there's a continued investigation beyond that, it could string on for a year.
I mean, it's not supposed to under the law. I'm not going to say those circumstances don't happen, but we have, in fact, if there's a window, if they believe that severe abuse, it has to be within, I believe, 42 or 72 hours. So we have different categories, but within 14 days, there's supposed to be a protection plan in place.
So you believe after 14 days, this would either be confirmed or dismissed, and a decision could be made whether this child could be homeschooled or not?
I would hope that would happen, yes.
Well, what if it doesn't?
If it doesn't, we would still be going through the investigation phase. I mean, if you want to fight it that way and appeal, I suppose you could hire an attorney and do that. But under the current law, we have a 14-day window, we have a 72-hour window, we have different windows based upon the suspected abuse level, okay? We can agree to disagree. If you think it's going to take a long time, I would say this fact pattern is a very rare circumstance to begin with. A very rare circumstance.
So I will agree it is a very rare circumstance, but I believe that it could be turned and used as a weapon against people that are choosing to homeschool, and that's what I'm trying to prevent.
How so? How is it a weapon? Wait. You think teachers are going to just file these things all willy-nilly? I mean, we just entrusted them with guns yesterday. I think we respect our teachers, and they respect the parents, and they respect the process. And if somebody files a false CPS report against you, guess what? That's a crime.
But throughout that entire process, now I have to prove that that was a crime. I haven't had the right to educate my child.
Look, it's a crime, man. It's a crime. If somebody files a false CPS report, it's a crime. You could take action. And not only that, if a teacher does that, guess what's going to happen to them? They're probably going to lose their license. There's no incentive for a teacher to make these things up. Now, and I agree, as I've had conversations, disgruntled exes, you're having disputes, there might be an incentive for someone else to file a false report. There's no incentive for a teacher to do that.
All right. I appreciate you
Thank you.
indulging my questions. Thank you, sir.
Gentleman number 49, Tully.
Thank you, Mr. Speaker. Will the gentleman from the 5th rise for some questions?
I haven't sat down.
Okay, very good. So I do think I think you have a very well-intended amendment, but I do think you have a process problem. How does the school superintendent know that the teacher, who is the mandated reporter, reported the abuse?
Because
there is
they have to report to the institution, so they'll have knowledge.
They do not have to report to the institution. I think is the way that I understand it, the DHHR reports back to the mandated reporter. So there's no guarantee that the superintendent has knowledge. And I'm going to read you something. It talks about showing of a probable cause. And it talks about when you come in for a petition to homeschool, provided that the county and superintendent may, after a showing of probable cause, seek a circuit court of the county an order denying home instruction to the child. The order may be granted upon showing of clear and convincing evidence that the child will suffer neglect in their education, or there are other compelling reasons to deny. Now, I would agree that probably somebody that knows about child abuse, that probably would be a compelling reason to deny, but I don't agree that the superintendent automatically has knowledge. In fact, I have House Bill 5330 that I filed this year that actually tends to address that.
No.
It requires...
I read your bill. It doesn't.
It does.
You're not reading from 803.
It requires the DHHR to notify each county superintendent weekly if there are pending abuse charges filed in the county on any child that is attending public school. And then it also requires them to notify them of any resolution of those pending investigations. So I think it does that my bill would, in fact, address a gap. I don't think that this necessarily does address a gap in which there's a knowledge deficit that a county superintendent could seek an injunction to deny a petition to homeschool. So I think we have some process problems here. I also think that in your
Are you asking me a question, or are you? I'm not sure what you're doing right now.
In your characterization of the Raylee event, were you aware that there was also another reporter that reported the abuse, and two different county CPS agencies did not do anything to intervene on that?
If you're suggesting that the CPS dropped the ball, I would agree with you. I'm suggesting that a mandatory reporter, there needs to be a prohibition involved. And I'll address you to 803, which talks about any person required to report under this article, a teacher, school personnel, or staff or volunteer of the public or private institution, school or entity, that they are tasked with immediately notifying the person in charge of the institution or school. So a mandatory reporter has to report not just to CPS, but to the institution itself.
So, but if
and that, to me, is the acknowledgement we're talking about. There's no gap. What you're referring to is if an individual who is not a mandatory reporter makes a report, that's not part of this amendment. So you're not speaking to the amendment when you speak outside of mandatory reporters.
Well, then let's go back to the mandatory reporters. You said school, so it could be the school principal knows, but maybe the superintendent does not. How do you define that?
Well, I would say the superintendent is technically in charge of the school district, which is the language used in the amendment.
Well, they're technically in charge, but you just said school, so which is it?
Yeah, I mean, if you want to go down that rabbit hole on the process, I understand you don't want to vote for it. You have that option. I know, what county do you represent?
This was actually occurred in Nicholas County, and then she was also transferred to Fayette County. There were two separate counties involved, two separate county CPS agencies involved. I'm also aware that the teacher that did do the reporting, her husband is the prosecutor in Fayette County as well. So if we're going to sit and hold a conversation about that, this has nothing to do with this amendment. I was asking questions about how do you address the gap in the knowledge that the superintendent may not have to seek the injunction to prohibit the homeschooling.
We're going to calm down a little bit here.
Yeah, I don't know what's going on.
The lady's recognized to ask questions on the amendment.
Gentleman's
authorized to, or is recognized to respond to questions on the amendment. Let's contain all of it to the pending amendment.
Yes, sir, thank you. How do you seek to address the knowledge gap that the superintendent may not have the knowledge to seek the injunction?
I don't believe there is a knowledge gap. I believe the requirement under the code requires that a report be made and it go to the person in charge of the institution, okay? You can say there's some gap in communication. The code is clear. It's clear. A report has to be made. It has to go to the head of the institution. Don't know what else to tell you on that.
Thank you.
Gentleman, 42nd, Douglas Steele.
The fifth yield. My friend knows swords. I think he actually got something worth working with here if you'll just work with me real quick. We haven't got a chance to talk about this offline.
Sure.
So you've got this thing pretty tight. And I work in front of Judge Blake. I work Fayette County. I mean, I know exactly what you're talking about here. There's a couple things here that that I want to bring to you, and just to see how you honest to God feel about this. For one thing, you start with the county board may not authorize instruction in the home. Do you see a gap here where someone can apply to be part of the virtual charter schools or go into a private school to escape a situation that's still left open here?
I mean, I suppose the private charter school may be outside of the confines of the amendment. I would agree that to an extent,
right.
possibly.
Well,
but I
and
think
there's
this
also
is,
the public virtual option.
yeah.
You know,
So,
that kid's.
I would say this is intended for the normal course of conduct, which is going from public to homeschool under an emergency set of facts. An emergency set of facts where there's abuse that may be taking place, and a petition was filed, and a report was filed by an actual school teacher. So, to your point, there may be other things out there that's not caught, sure, but I think this grabs probably 90% of the possible scenarios.
Well, a lot of what we're seeing right now, data-wise, coming back is more people are actually opting for like the K-12 or the charter, the virtual charter, than actually the homeschool instruction right now, because
Sure.
you're not having to pay for all that curriculum. I mean, a lot of homeschool parents are paying $5,000, $6,000, $7,000 a year for that homeschool curriculum. They're actually, when you start to talk to a lot of our boards, they're seeing folks pull out, go into either one of the virtual charters or the public virtual option, which I don't think your amendment encapsulates.
And if you would like to reform to expand my narrowly tailored amendment, I'm happy to entertain it, but I'm happy with this current version, which is very narrowly tailored.
The other thing that I wanted to ask you about, and again, I mean, no sword here, it's just me and you talking.
I like it.
Against either custodial parent. So let's say that, you know, we're in 50-50 land now here in West Virginia, and let's say you have a father that has 50% of the time and a mother that has 50% of the time, and there's an allegation of abuse against the father, and it's some type of sexual abuse allegation or something like that, and I've actually seen this happen where they want to pull the kid out of school because kids at school have learned of the sexual abuse, and it's become embarrassing to the child. There's no allegation against the mother. The mother wants to pull that kid, into a homeschool situation. The way you've got it worded, if either one of those custodial parents, then you wouldn't be able to do the pullout. Do you see that?
I do not, because I believe this goes to the individual who would be applying for the ability to instruct the child at home, and not just, I think you're reading beyond the language. The language insinuates that it would be the individual responsible for instructing the child. So it would be either parent who says, I'm going to homeschool, or a person that's not the parent instructing the child.
And that would be who the allegation was against?
It would have to be against the individual. The allegations have to be against the individual planning to instruct the child.
See, I don't see the wording. It doesn't say that to me.
So either custodial parent.
Against either custodial parent or a person instructing the child.
Yeah. So mom, dad, person instructing the child.
Yeah,
It's
so
the
there's
person instructing the
potentially
child.
three different parties there. That's
Sure.
an or and not an and.
No. Those are the only three possibilities: father, mother, or an individual instructing the child. So it's the individual who wants to do the home instruction. Clearly, that's who it is. So if the mom wants to do it, and there's an allegation against the mom, that's an issue. Father wants to do it, there's no allegation, there's no issue.
So you're saying that the way you got it constructed right now, you believe that in that scenario I described, that the father's got a sexual abuse allegation against him, the child is in a bad situation at school because people have found out about it, mom wants to homeschool. You don't think that your amendment's going to prevent mom from doing that?
No, I do not. I do not. In that fact pattern, the person asking to be authorized is not the person with the pending allegation against them.
Right.
So therefore would not qualify.
Okay. The last thing that I wanted to bring up is the mandatory reporting, that the board may not authorize instruction in the home if there is pending child abuse or neglect investigation. Now, there's no time period set, and we talked about 14 days. We talked about the idea of I believe you're talking about a ratification that happens within 48 or 72 hours.
Yeah.
One of the statistics that I've heard over the last 2 years coming from DHHR is there is such a heavy burden on a teacher to be a mandatory reporter that it's been found that over 90% of reports from school personnel are unsubstantiated. So could you see that there be some type of time limit on this of 10 days, 14 days of, some type of cap here?
If you would like to reform it to have a cap, I would entertain that. I believe we have already parameters in place and timelines. You talked about the 14 days. And at the end of the day, mere inconvenience is not enough reason to not protect our children, in my opinion.
Like you said, man, there's no sword out here.
Sure, I know.
I think you've done one of the better amendments I've ever seen you do here.
I care about this.
I know, and you've been fighting for it for several years. And I think my side of how I feel about it as a homeschool parent. It's easy to see this as a little bit of an attack, but I think all of us got to acknowledge that the situation you're talking about has actually repeated itself elsewhere. I feel the same need to protect that child that you do, and I think 100 out of 100 in here don't want to see a kid get hurt.
Sure. And I've done my best to try to alleviate those concerns.
Right. I guess the one thing that I would ask, just outright to you, is with those couple of concerns that I brought up about making sure that a non-offending parent could still kind of pull the kid out, that we talk about the other private school, virtual charter or virtual public options, as well as setting a cap. You're going to get too mad at me if I ask to lay this over a day to where maybe me and you can try to work something out on this?
No.
Okay. Mr. Speaker, I would move that the bill be advanced to third reading with amendments pending and the general right to amend.
Gentleman from the 42nd moves that the bill be advanced to third reading with the amendment pending and the general right to amend. Are there objections to that? No objections are heard. Bill be so advanced. Clerk will please report the next bill on second reading.
Committee substitute for House Bill 52.